Good afternoon, everyone, and thank you for joining this Use Laboris webinar. My name is Alessia Perez, and I will be facilitating the session for you today. Today's webinar will be given by a set of panelists, all from different member firms of Use Laboris. Today, we have lawyers from Belgium, Chile, France, United Kingdom, and Italy, our moderator. Before we kick off the session, I would like to clarify a couple of points on the housekeeping side. If you have any questions throughout the session, you can use the Q&A tab to send your questions to us, and panelists will answer as many as they can at the dedicated Q&A session. You can, of course, also reach out to the panelists via email after the webinar. The webinar is recorded, and the recording will be available on our website in the coming days. I will now turn over to Melania Soncin, our moderator from Toffoletto De Luca Tamayo, the Italian member firm of Use Laboris, to begin the session. Go ahead, Melania, you are welcome to start.
So thank you, Alessia, and thank you everyone for joining. Now, in our globalized world, I think it is very easy for people to jump on a plane, go to another country, speak with colleagues, maybe have some meetings, come back in a few days. And companies in these cases don't really think too much about compliance. They just brand these situations as business trips and quite lightly, let's say, manage them without thinking that there is much to take care of, many risks for them. But actually, in all global mobility cases, so when employees travel to a different country, it is always important to be reminded of the fact that there are different areas that have to be considered. So immigration, social security, taxes, employment rights. So the purpose of this webinar is really to understand when we are in a business trip scenario and what companies should consider to avoid just not keeping track, let's say, of what happens and then encountering risks they are totally unaware of. So we will be doing this today with our panel of experts. So we have Sophie Maes from the Belgium law firm Claes and Engels. We have Gonzalo Zuniga from our Chile law firm Munita Olavarria. We have Naomi Hanrahan Soar from the Luciok in UK law firm of Use Laboris. And finally, Virginie Pecorella from our Capstan French Use Laboris law firm. So first of all, I would, let's say, I will stop in with these slides. So because our purpose is to have a bit of a conversation with you. And let's start from the beginning. So what I would like to know is if in your countries there is a definition of business trip and business traveler, and what does this entail? So let's start from Naomi.
Hi, thank you very much, Melania. So there isn't, strictly speaking, a definition in the UK immigration rules. The UK has what we call a standard visitor route. That is a change from what we used to have some years ago, where we had multiple different types of visitor routes. This means that we have one kind of catch-all, and that includes the business visitor within it. So it's a broad framework trying to encompass many different types that will include things like creative visitors, standard holiday visas, and business visas. In terms of the conditions, it's crucial to understand the work prohibition, because that's probably the most important for the audience we're talking to. Visitors cannot work physically in the UK, irrespective of the length of time, unless the specific activity is a permitted activity. There's a defined list of activities that are allowed for inter-corporate purposes, where the visitor is employed by a group entity abroad, for people supplying goods to the UK, for creative workers, sports people. It's important to assess the proposed activities for each trip to check whether or not those are allowed from that list of permissible activities. And the immigration rules and guidance set out what you can and cannot do on a standard visit. For example, general business activities like attending meetings and conferences are permitted. A new edition allows them to undertake activities relating to their employment overseas remotely from work, providing this is not the primary purpose of their visit. And that was something that sort of acknowledged what we already had going on a lot in the world, particularly post-COVID, and exactly as you explained at the beginning, where people find it very easy to jump on and off flights and on trains to go from country to country and do a bit of work while they're abroad. There's some other conditions as well. So there's performing the permitted activities must not amount to the visitor undertaking employment in the UK or doing work which would be the same as them filling a role or providing a short-term cover for a role within the UK organisation. There's also a requirement that the visitor is already paid and employed outside the UK, then they must remain so. Generally speaking, they usually will be paid and employed outside the UK anyway, because it's very rare for that to fit within the purpose of the rules. That's because there's no restrictions on receiving payment in the UK for activities. Sorry, there are restrictions on receiving payments in the UK for activities, unless it's sort of one of the permitted paid engagements, which they're going to complete within 30 days of arrival. I'm conscious I'm taking a long time, so my last point I want to make on this question is that in terms of how the individual applies for the visa and the validity period for it, if the traveller has a nationality that is eligible for the UK Electronic Travel Authorisation, or ETA as we call it, they would need to ensure that they have a valid one of the ETA approved before they enter, and then they could stay for up to 6 months per visit. There are other nationalities not on that list who need to make a more formal application. However, even if the visa is valid for several years, which is a possibility, so this particular route where you're applying for the visa, you can apply for even if you're an ETA nationality. Say you just visit frequently because you have an office in the UK and you're based in Belgium, so you're coming in and out all the time. Once you establish a pattern of doing so and they consider you trustworthy, you can apply for 2 years, 5 years, 10 years. But even in that scenario, each individual stay cannot amount to more than 6 months. And it's very, very rare for somebody to stay within the restrictions of the visitor visa and go up to 6 months. I'll move on to Sophie.
Thank you.
Yes, hello everyone. Perhaps a little word about Belgium. Do we have a definition of a business traveler? Well, actually, no. As such, there is no legal concept related to a business traveler. In terms of immigration, we have a bit of a similar approach, as I understand, as the UK now. For those employees who do not have European nationality, the principle is that they should have a Schengen visa unless they are exempt from a Schengen visa. But in terms of a Schengen visa, that is for all purposes of a visit, both related to business, but also for leisures. So no general definition, but what we do see in law is that we have several applications where it clearly refers to a business traveler. For example, in our Limosa legislation, and Limosa is in Europe the posted workers declaration, which is something which is mandatory both for EU nationals and non-EU nationals if employees are being sent to Belgium. Well, there is an exemption for attending meetings, what we call in a closed circle, but only if those meetings do not take more than 20 consecutive days or 60 days in total. So indirectly, that refers obviously to business travelers who attend such meetings. And we have a similar exemption for the work permit, because it's not because we can enter with the Schengen visa Belgium that we can work here. Then we need to look whether there is a work permit needed. But we do have a similar exemption for a work permit for attending meetings in closed circle for maximum 20 consecutive days per meeting or 60 days per year. That is the general exemption. For UK nationals, we have a more broader exemption under the Trade and Cooperation Agreement that can be extended up to 90 days. And for more even activities than normally just attending business meetings, and we have a similar exemption, but it only exists in Flanders and in Wallonia for sales activities, which can also be without work permit up to 90 days in a period of 180 days. Perhaps one thing already to consider, work permit matters in Belgium differ according to the applicable region. But that is Belgium, so I think.
Wow. And if we fly across the Atlantic to Chile, Gonzalo, what is the definition there?
Hey, everyone. So in Chile, we do not have any specific statutory definition of a business traveler as well. In practice, it falls under the transient stay for tourism, business management subcategory provided in the Chilean immigration law. This status allows short visits without the intent to reside, typically for meetings, visits to clients or suppliers, prospecting, and executive activities. So transient stay authorizes up to 90 days, extendable for another 90 days. And it might require a prior consular visa, depending, of course, on nationality. And it always requires a proof of lawful means of subsistence. It is critical that the stated purpose match the activities actually carried out. And it's critical as the authority might deny entry if it detects discrepancies. So the key limitation is performing remunerated productive activities in Chile, as a tourist cannot work except for narrowly tailored permission for specific and sporadic tasks, such as conferences or very limited technical assistance. So in short, a business traveler in Chile is a tourist with a business purpose who does not perform productive activities or remunerated work in the country unless an extraordinary and specific authorization have.
Okay. And Virginie, what about France?
Yes, hello everyone. It's also similar in France, so I will keep it short. It's the same. We have no legal definition of a business traveler in the French legislation, but the term business traveler is used in certain situations, notably on the official website for the visa application in France, or on specific guidance for social security. We will discuss a bit later. But when we see the definition or the term when it's used, it's more qualification of the activity, of the nature of the travel, purpose of the travel that will be taken into account. We have some example in the guidance from the authorities, conference, seminar, visit client, Teams meeting, network events, this kind of activity. So it's not productive activities, as Gonzalo explained for Chile, or no effective work. It's more this kind of activities that will be allowed for the individual. For the entry in France, it's the same thing as Sophie explained for the Schengen area. The individual can enter France or Schengen area and stay for 90 days within a 180 days period. And depending on citizenship, a Schengen visa may be required or not. Some are exempt from the Schengen visa, but no more than that.
So what I understand from all your inputs is that instead of focusing really on the duration of the stay, the company should have an eye on the activity that is performed abroad. So it's not just because I'm traveling for 2 days that this necessarily means that I am a business traveler. So to make this a little bit more real, I think it is good to go through a couple of examples on which you could comment. So I would say let's start from maybe what the easy one is, we will see. So if we have an employee of a company which goes and travels to another country to partly, I don't know, meet with some group colleagues of another entity, and then maybe they have to finalize negotiations on a commercial contract, meet some clients, and they stay again for a short period. Sophie, can we agree that this is a business trip?
Well, I would say for me that would be the very good example of a business trip. So as long as we stay under the 20 days, then it would be a meeting in closed circle, meaning that we are both exempt from a LIBOSA declaration, which is our posting of workers declaration, which also applies normally to business travel, unless if we are under those 20 days meeting in a closed circle. But it would also, because we are here dealing with a non-EU national, it would also be an exemption from a work permit. Imagine that those conditions are not complied with, so after 20 days or it's longer, then we would need to do a Limosa declaration. But depending on the region, it might still be that the person is exempt from a work permit. First of all, if they're UK nationals, because there we have more exemptions, it's a bit broader. It can even go to 90 days. And the same in Flanders and in Wallonia, where we also have an exemption from a work permit for sales activities, but that is defined quite broad as well, also up to maximum 90 days. But that is only Limosa and immigration. In terms of employment rights, that may still be applicable, and the same for Social Security, but I guess we will talk about that a bit later.
Thank you, Sophie. And Naomi, do you want to comment from the UK perspective?
Yeah, and I'm delighted to have gone from being the longest answer in the last question to the shortest in this one, because both of those activities are very clearly listed as permissible activities, so it falls very neatly into the visitor visa category.
Thank you. So let's try and make it a bit more complex with another example. So we have, let's say, a US citizen, which, however, has a long-term work permit in Italy, and they are a store manager, they work in the retail sector, and the group is Italian-based, so they want to guarantee, let's say, uniformity of their policies and ways of sale around the globe. So basically, the store manager is sent in your countries to train the store managers who work in the different shops and show them how to set up the shop, how to sell, how to keep the registry. And this is done during the working hours, so with the public, so it is really a training on the job. Now, in this scenario, Gonzalo, what would you say? Is this a business trip if the time is, for example, very limited, 1 week or so?
No, this case is very different. So when a store manager from an international group travels to Chile for 1 or 2 weeks to supporting the opening of a location and conduct on-job training with the local staff during working hours, that in this case, the activity is deemed productive and it's closer to an employment relationship than a simple business trip. So therefore, a typical transient business stay alone it is not sufficient. So one must request an exceptional work authorization. Of course, if the intervention is brief and technical, or even a temporary residence permit granting work. So if the talks involves subordination, operational integration, or intensive execution. So regarding the penalties, if a foreigner works without the appropriate permit, they risk a fine of approximately 36 to 362 US$. And of course, the Chilean employer must incur in penalties depending on the size of the company. And furthermore, there is the risk of being denied entry or being expelled for working without authorization. So it is essential to carefully assess the nature of the mission and, of course, secure the correct permit or visa before travel.
Thank you. And Virginie, what about if the store manager was sent to France?
So if the activity will be performed in France, I will agree with Gonzalo on the analysis. The activity is more a productive work than a business trip, because the individual will continue to perform his or her duties during this period in France. So I will consider this is not a business trip, which means that in principle, the employee is required to obtain a work authorization. So even if it's for a short duration, but obtain a work authorization before being able to work in France. However, we have in France some work permit exemption for individuals coming to France for short duration and to work in specific sector or for specific activities. And in particular, there is a work permit exemption that can be applicable here or to discuss. It's for employees coming to France to provide an expertise or to conduct an audit in some specific fields listed by the authorities, so IT, management, finance, and a few other, but not relevant here. So It can be either under an intra-group agreement or in the context of a service provision with a client, for example. And of course, the employee should not stay in France more than 90 days, as we explained earlier. And the individual should be able to prove that he has sufficient experience to prove the seniority and the expertise. So it's very useful exemption because the scope is quite broad. You have to provide an expertise or to conduct an audit. It can be a lot of things. And in our scenario, maybe we need to check, but maybe a kind of management-related expertise that can be applicable here. It means if the work permit exemption is applicable, if the employee can benefit from it, of course, work authorization is no longer required. But the employee and not the company, the employer, will still require to submit a posted worker declaration. It's called also CIPSI notification. In France, CIPSI is the website for submitting the notification. And this document corresponds to a notification to the French Labor Inspectorate to indicate them that a non-French company is assigning employees to France. So no work permit exemption, but still a posted worker declaration. And if the posted worker declaration is not submitted, there is a risk of fine for the employer, the foreign employer, which is 4,000 euros per employee if there is an audit from the authorities.
Thank you. And Sophie, what about Belgium, which is always very easy, I think?
Well, it's a very tricky one, if that is a good answer, because we do have in Belgium exemptions, as I already was saying, in Flanders and in Wallonia for sales activities. And sales activities include giving and following a training. But that's it, giving and following a training. The conditions is that it's up to maximum 90 days in a period of 180 days. And the condition is also that a Limosa declaration, a bit the same as Virginie was saying, as our posted workers declaration has to be done. But that is only in Flanders and in Wallonia. In Brussels, we also have an exemption from a work permit for training, but only between group companies, whereas in Flanders and Wallonia, it's in general, and only if there is a training agreement. So what I would say here, the big question will be, to what extent can we really consider this still as a training? So I think I would, as a lawyer, ask for more detail. What would the person do? If we are lucky, we can use the exemption. If we are not lucky, or if it is too tricky, we would need to apply for a work permit. And that is quite important if it is applicable, because if we don't do it, then the penalties for having somebody working without a work permit are quite high. It's criminal penalties or administrative penalties, but it can also have other consequences for the organization, because if there is an audit or whatever, and this has been flagged, the next time as a current organization you apply for a work permit, it can become much more difficult if you have already been catched, so to say, without having employees work without the relevant work permits. If employees are overstaying, obviously that also has important consequences, because then they can be refused to enter the Schengen area the next time. If we can use the work permit exemption, as I already said, we would need to do in any event a Limosa declaration. Not doing the Limosa declaration also triggers penalties. And if we have to apply for a work permit, then we also need to do the Limosa declaration, and that will, in any event, in this case, be applicable. If we don't do it, it's criminal penalties quite high. It's the highest criminal penalty for the employer, can be up to technically more than 500,000 euros. But also the receiving company in Belgium is at risk, because there is also an obligation for the Belgian receiving company to check whether the Limosa declaration has been done. If it is not done, then the Belgian company needs to file the application, and also subject to criminal penalties if the Belgian company does not do the Limosa declaration.
So we need to remember about the Minimum Declaration, I would say, which is really an unicum in Belgium. And Naomi, what about the UK?
Yes, but you would probably need more detail to confirm. Pre-travel assessment is essential to make sure the planned itinerary aligns with the visitor route or identifies when a work visa, i.e. something like the skilled worker visa or global business mobility, is required, to make sure that you avoid any unlawful work and immigration breaches, which I'll come to in just a second. Under the visitor route, the scenario wouldn't fall under general permitted activities. It would probably fall under what we call the intra-corporate activities. Under the intra-corporate rule, an employee of an overseas-based company may advise or consult, troubleshoot, provide training, and share skills and knowledge with UK employees of the same corporate group, provided this is on an internal project being led from the UK branch. So some limited work directly with customers is allowed in that scenario. Early assessment enables compliant documentation to be prepared and handed over if questioned by the UK Border Office. And documentation could include things like an invitation letter from the company you're visiting, some detailed agendas, proof of your overseas employment and remuneration. They want to be able to see you're not going to be paid in the UK and be working in the UK. If you misclassify the trip as a business visit rather than a work visa, then that can result in illegal working. So penalties for illegal working in the UK are very high. You're looking at a civil penalty which starts at £60,000 per illegal working. So that's 60000. And you can sometimes take it down, but only in certain circumstances. And what they will first do is ask you for some questions that sometimes I find people find look quite innocent and they respond to without realizing how serious it is, and then they just whack you with a fine, by which point it's quite difficult to get off, though thankfully we are very good at it in my team. If they're knowingly employing an illegal worker, though, then and when I say knowingly, it's important to recognize it's not just that they actually know, but that they should reasonably have known that they're employing somebody to work illegally. Then there is, in fact, a criminal prosecution with an unlimited fine and up to 5 years imprisonment. So that's very rare, but that is possible as well. The individual risks refusing entry at the border. They could get a ban from coming back to the UK, and they could also face themselves an unlimited fine and up to 6 months imprisonment. So again, prosecution is rare on the criminal basis, but being whacked with a ban from coming to the UK and being refused entry is a lot more common.
Wow. So yeah, we're so used to go back and forth with the UK. Now we need to pay a lot more attention. So far we have a bit concentrated on definitions, especially from an immigration perspective and limitations. So this is the first, of course, area we always have to be reminded of, I think, when sending employees abroad. But then there are the other areas. So I would like to move to employment rights and understand if to what extent these business travelers risk acquiring employment rights from the country where they are moving to for their business trip. So, Sophie, what do you say on this?
Yeah, yes, so if we talk about employment rights, especially in global mobility, when we are moving people from one country to the other country within the EU, we always have to think about the Posted Workers Directive. The Posted Workers Directive is a directive which has been adopted on European level with an aim to fight against social fraud and unfair competition. And the way the EU wants to do this is to say, well, if you're sending out your employees in the framework of a cross-border provision of services, that employee comes obviously with his own employment contracts, own employment rights from the home country. But when the employee comes working temporarily in the host country, that then a minimum set of hardcore terms and conditions of the host country always apply, irrespective of the law that applies to that employment contract. So that is a bit what the EU foresees. If you send somebody to another country to work there temporarily, you need to respect from the host country in the member state a certain minimum terms and conditions. On EU level, this has been constructed within the framework of a cross-border provision of services. So it means that there needs to be a recipient company in the host country, but that is Europe. What Belgium has done is Belgium has implemented that directive in an extremely broad way. and has said, well, actually everybody who comes and who works on our territory, they need to comply with this hardcore of minimum terms and conditions, irrespective of the duration, so if it is only 1 day, and irrespective of what you're coming to do. So we, from a Belgian perspective, do not require that it happens within a provision of services. It's just sufficient that you come here, you work here, and then this hardcore of minimum terms and conditions according to Belgian law applies. So if we apply that, at least from a theoretical perspective, our law on a business traveler, then the business traveler falls, from a Belgian perspective, under our local implementation of the Posted Workers Directive. I'm convinced that this is against the case law of the European Court of Justice, because the European Court of Justice has said that there has to be a sufficient link. But anyway, our law is what it is today. Technically, it still applies also to business travelers. So that's one thing. The second thing, what Belgium has also done, is not only the scope of application interpreted or implemented in a very broad way, but also our hardcore. The hardcore of minimum terms and conditions has also been implemented in Belgian legislation in a very broad way. Under the directive, it refers to 9 matters. Well, in Belgium, we have defined those minimum terms and conditions are all working, employment, and remuneration conditions which are criminally sanctioned or which are provided in a CBA that has been declared general binding. That is, to make a long story short, or sector CBAs. So what you should know is almost everything in Belgian employment law is criminally sanctioned, and we have a lot of sector CBAs. So to make a long story short, it applies to a lot of things like wages, premiums that are provided at sector level, indexation rules, etc., etc. So from a theoretical point of view, all those employment rights do apply to business travelers. Whether that is the case in practice, that is something else. In practice, I do not think that everybody is always complying with it, but from a legal perspective, they fall under that. Yes.
Thank you, Sophie. This is very interesting from also an Italian perspective. And Virginie, what about France as another EU country? What do you think?
Yes, in France also we have implemented the Posted Worker Directive. For the scope, it's I would say similar to Sophie. We have an extended scope compared to the directive, because under French legislation there is a specific category of posting not provided for in the directive, and it's called posting on own account. So it's the situation where the employee is traveling and in France for the benefit of his employer, with no client or receiving entity in France. And one of the examples listed by the authorities is to participate in events in France. So typically the activities that can correspond to business travelers. So they are classified as posted worker, but they are exempt from some formalities. We discussed just before the posted worker declaration, the 60 notification. So in principle, it's applicable to all posted workers, but not for this category of posted workers, so not applicable to business traveler. And the second formality is not applicable to them if the need for the employer to appoint a representative in France to liaise with the labor inspectorate in case of audit of the situation. So 2 formalities are not applicable to the posted worker. But on the other side, they are posted workers. So in principle, the hardcore of French rules, mandatory rules, also apply to them. And it's a large scope of the French employment legislation. There is a list, but just to give some example, it can correspond to maternity, paternity rights, right to strike, duration of work, vacation, daily working hours, remuneration, the same level of compensation between the employees. So it's quite a large scope. Even if in practice, I'm not sure there is a a risk of audit on this population because we are talking about people coming for a short duration in France, but in principle they are supposed to comply with those rules, mandatory rules from the French legislation.
So yeah, this is interesting because short trip, but then not forget employment rights. And Gonzalo, moving out of the EU, what is your perspective?
No, in these cases, as there is no provision of services based on an employment contract or a work permit, local labor rights are not acquired. So the focus is on immigration and the veracity of the purpose of the trip. And of course, if the employment relationship is demonstrated and there is no work permit, fines might be incurred.
So lighter, so that's scary. So instead of moving to another area, because I said, immigration, employment, we always have to think of the different areas of the law, moving to social security. So does doing business travelers need to, ask for a certificate of coverage or something like that to ensure that they do not need to pay double social security or social security in the place of destination? Gonzalo, I'll stay with you.
Yeah, so for a pure business trip with no work performed in Chile, there is generally no obligation to register for a Chilean social security or obtain a local social security documentation. However, if the remunerated activity or an employment relationship in Chile is involved, the Chilean social security rules will apply. And where Chile has a bilateral or multilateral social security agreement with the employer's home country, it's advisable to always carry a valid certificate of coverage to remain affiliated to the home country social security system during the temporary assignment, and of course, avoid double contributions. So note that the EU's A1 form does not apply here in Chile, and the coverage must be certified under the relevant agreement. So companies should verify whether a social security treaty exists, and if so, secure the certificate of coverage before travel whenever any service, so even short-term services will be performed here in Chile.
Thank you. And Sophie, what about in Belgium, if we travel to Belgium?
Yes, well, we have already heard the A1 form. So the A1 form comes from Europe, because in Europe it's again governed by European legislation if we are traveling within the EU. So if we are coming from another EU country under European legislation, we call it a posting, also a business traveler, and the employee can remain subject to his home country social security. Under the current status of the regulation, because it's governed by regulation in the EU, Regulation 883, technically for a business traveler, they need to have an A1 form. The EU is negotiating, or at least looking at changing the rules, but I think this is an exercise that started already in 2016 to exempt business travelers from the requirement to have an A1 form, but at the moment they did not yet manage to change the rules. So technically, you should have in the EU an A1 form for your business travelers. In practice, in some countries, some are more relaxed on this than others. I think it's important to note that on an EU level, there are no penalties if you don't have an A1 form, but there can be penalties on a local level. Belgium, we do not have penalties. If somebody does not have an A1 form, we will not fine that person. However, in particular, if it takes a bit longer, it is important, and it has a lot of advantages to have an A1 form. First of all, because an A1 form is binding, so the Belgian authorities cannot question the A1 form and must accept it. There is a way to, nevertheless, not to take into account the A1 form, but that is really an exceptional circumstances of fraud and etc., but not applicable, I would hope, to business travelers. Also, in case of an inspection, if you don't have an A1 form, that may trigger attention of the inspection and go look of them a bit more deeper in detail. But I think the most important one is if something happens. If something happens, the person has to go to the hospital, etc., then it's always good to have an A1 form. The only thing that I want to say here is be careful for some sectors in Belgium. It's more relates to provision of services than really actually business traveler, but we have some sectors like the construction sector where if employees do not have an A1 form, that then in that case, but again, it's provision of services, the Belgian company starts being jointly liable for any social debts and must withhold 35% withholding from the invoice to the foreign company. So in those specific sectors, you may be sure you will not get into the construction site if the employee does not have an A1 form. So, but that is inbound business travelers or inbound postings to Belgium. In relation to outbound postings, if you do not have your A1 form because you go to another country in Europe, but there is there a control. The Belgian authorities do provide retroactively also A1 forms. Of course, you don't need to exaggerate. You don't need to come after months and months. But if it is just a few days or a week, they are quite cooperative to give it also. And it's also in line with European legislation.
Thank you, Sophie. And what is the French position on this, Virginie?
Yeah, for France, there is no exemption under the French legislation from the requirement for employees coming to France, so business travelers coming to France to produce what they need, and A1 or a certificate of coverage if it's not a European country when they're coming to France. In case of audit from the authorities at the employees' place of work or place of stay, failure to produce a certificate or at least to produce an proof that the application has been filed may result in a fine. It's quite similar to the one discussed earlier, so 4,000 euros per employee. And in principle, if there is no social security agreement with the home country, it means that in principle, the payment of French contribution is due, which require the foreign company to register in France. So I'm not sure the employers will do this. And even if they want, the process takes several weeks. So the employee will be back to his home country. But it's at least what in principle is supposed to be done. For the outbounds, it's quite creative, I think, because for French business traveler going abroad, we have, it's recent, it was implemented last year, I think, or 2 years ago. The French authorities apply a tolerance to reduce the administrative burden for the French companies. So it's allow the French company to be exempt from requested an A1 certificate for business trips. So it's only A1 certificate because it's specific to the EU regulation, and it's linked to the European project to change the approach on this. But there's no guidance regarding the duration of the trip. So we do not know what is a business trip to qualify for the exemption. There is a kind of description of the activity. It's an employee who is temporarily abroad for professional reasons. We have some activities as example, but no explanation on the duration. So quite difficult to use this tolerance because we do not know what activities, what travel can qualify. And in practice, even if we can have such exemption, we still need to take into account what is indicated on the host country legislation. If the A1 is required by the host country, it means that the French employer will need to apply for this A1, even if it can be also retroactive, but if it's mandatory for the other country, we have to do it. So the recommendation will be more to apply for the A1, even if it's a short business trip. And doing so, we will have a document available if requested by the host country, but also if there is a medical issue or an accident for the employee during the travel, it's better to have the document before the issue happened.
Thank you. So staying with you, Virginie, as you're also a tax expert, and I think taxes is also a very sensitive matter for companies. Would you like to give us a bit of an overview of the principles of tax legislation when it comes to business trips?
Yes, so from tax perspective, I will just elaborate on the income tax for the employee, not PE for the company, because if it's business trip, it's quite limited on this part. But for so income tax and potential tax due on the remuneration paid to the employee for the activities to be performed for the day worked in the other country, in principle, there is no tax consequences if we have a double tax treaty applicable between home and host countries. There are specific provision in the double tax treaties relating to this kind of situation. And the purpose is to keep the taxation in the country of residence of the individual, and so to avoid the taxation in the country where the activity is physically performed, provided that several conditions are met. So the wording depends on, of course, on the applicable double tax treaty, but it's based on the OECD model, and we have 3 conditions to meet. The employee stay in the host country, so country where he will travel for less than 183 days in either any 12 months period or the fiscal year or the civil year. So should be no issue with this condition, because we are talking about a short travel, and even if the employee has several business trips to the same countries, it will not exceed the 183 days threshold. So first condition, duration of the stay. Second condition, the employee does not have an employer in the host country. There are different approaches on the concept of employer, but here also, given the nature of the activities performed by business traveler, it's not expected that they have an employer in the host country. And the final condition, last condition, is the employer does not have a permanent establishment in the host country and will not recharge the cost of the traveler to this permanent establishment. So it's more complex condition, because it requires first to have a permanent establishment in the host country and then to recharge the cost of the traveler to this establishment. So in principle, no issue also with this condition, since we're talking about business trip. So if all these conditions are met, no income tax in the country of travel on the compensation relating to the day work there. Similar to Social Security, if there is no double tax treaty between the countries, it means that in principle, we are supposed to follow the principle of territoriality. So potential taxation in the according to the local legislation in the host country. So need to check if there are some exemption or if there is a taxation as from day one. Maybe it's theoretical, but something to change depending on the countries. There are a lot of double tax treaty all around the world, so maybe more theoretical again, but to check.
Thank you, Virginie. So before moving to our Q&As, if everyone wants to just add a short comment, recommendation for our audience. So now I'm starting from you.
Yeah, so I think the key takeaway that I'd like to leave people with is that now advanced planning is really essential. In the UK, it's crucial to evaluate each activity against the relevant rules and guidance to determine whether it's permitted. It can sometimes still be ambiguous, and given the severity of the potential penalties for non-compliance, seeking expert advice is often advisable. It's also essential to ensure that any previous convictions of the applicant are assessed. The way that the ETA is set up means that these must be declared and a visa application made, which can more often lead to refusals than before ETA was introduced, because the ETA would automatically refuse in those circumstances. So sometimes we've had, in particular, creatives, musicians and the like that might have had a relatively minor conviction in the past and they've travelled previously without a problem. But now with the changes, actually they need to allow a lot more time for that application so they can make a formal application and deal with the automatic refusals.
Thank you. And Sophie, what do you want to leave our audience with?
Sorry, I had myself still on mute. Yeah, I just agree also to what Naomi was saying. I would say do not think too easily, oh, it's just a business trip, everything is okay. Because you need to look at different aspects. We have immigration, we have tax, we have social security, we have employment rights, and we have home country, but we also have host country. So it's important to, I would say, start in advance and perhaps to create business processes around this, because once it is more structured, it will be more easily to apply, and also to well communicate within the organization and also the managers, etc., to train them. So I would really advise to have clear processes in place, so to avoid unpleasant surprises.
Thank you. And Gonzalo?
Yeah, in summary, to minimize risk when sending foreign personnel here to Chile, it's essential to assess the immigration category based on the actual activities to be performed, clearly distinguishing between business meetings from operational or productive work, and to carry solid evidence of the trip's purpose. On the job training should be avoided under a simple business status if unavailable. A specific work authorization is required, or a temporary residence must be obtained. Every case must also ensure alignment between immigration, labor, and social security compliance, as performing work in Chile triggers contractual, social security, and potentially tax obligations. So understanding the applicable sanctions and planning ahead for required documentation is key to ensuring a fully compliant assignment supporting international mobility, especially without exposing the company or its professional to unnecessary risks.
Thank you. And Virginie?
Yes, similar to the group, we do not need to spend sometimes a lot of or to check a lot of things, but we do not need to consider that it's only a few days, there's no implication, there is no risk. We have to check implication from the home country, from the host country also, because it's international mobility, so it's legislation from home and host country that will need to be checked. It involves several matters, so things have to be checked not only from an immigration perspective. Sometimes it's the one the company are the most aware of, because it's immigration and access to territory. So it's the first step, but other implication can be triggered by a trip. The nature of the activity, what we discussed at the beginning, it's an important point, not only the duration, because it's the key factor that will allow to identify the applicable obligation. And from a company perspective, clearly identify the population of business traveler in the organization, try to have rule implemented for this population, because it's different from a short stay assignment, a long stay assignment. It's a separate population, so have specific rules for this population, and for all the parties in the company to be aware of such a rule, because it's not only HR or mobility team, but business and managers should be aware also of those rules and the risk, because they may approve the travel, so they need to be aware of what it will be what will be the implication of the travel for the company, and to avoid any risk as far as possible.
So thank you all. Now we will leave some time for the Q&As. Before I do so, and this is actually linked to one of the questions we received, I just want to flag to our audience that these were the views from 4 countries, but actually in Youth Laboris we have just put online a project, a business trip project. We have basically done a survey of around 30 countries on the key aspects that need to be considered when sending employees on a business trip. So on our website, here you find the link, you can find this chart with some key matters to consider for a huge number of countries. So this, then of course you can reach out to us separately, but I think this is already a very interesting overview for you all on the differences between the different countries. Now, Alessia, did we receive some questions from the audience? And who hasn't still put their question, they can put it in the box.
Thank you, Melania. Yes, indeed, we have received some questions. I will start with the first one about working time for you, Sophie. I would appreciate your views on whether the time spent during business travel should be regarded as working time or rest time.
Well, that is a very tricky question. And I think in a lot of countries, giving rise to a lot of debate. So my first answer would be you need to look at the law that applies to that contract and to see under that laws whether they will consider travel time as working time. However, I can say very high level something about Europe, because in Europe, working time is governed also by a directive. Of course, every country has implemented it in its own way, but under European legislation, working time is the time that an employee works or that carries out his activities and his duties, or is at is at the disposal of the employer. So the big question is, if we do travel time, is the employee then working, or is he at the disposal of the employer? There has been already some case law about this on a European perspective, but that mainly relates to mobile employees, so like technicians. It's not really travel time, but it's just to make the bridge, where the court says that the travel time to go to the first client and then to come back from the last client, that is to be considered as working time. So the big question is, what do we now do with our business travelers? Because that is more ad hoc, that is not part of their duties. Unfortunately, there we do not have a unified vision on a European level, and it's really, you need to look at the more local level. I can say for Belgium that it will quite often be regarded as working time, which obviously makes it extremely difficult, because on an EU perspective, you also have this requirement to have 11 hours of rest between 2 sets of working time. So with the traveling, that can become very challenging. And then as regards the other EU countries, but I'm also looking at Melania, she can perhaps say something.
Yeah.
I think the position is different, but let's know, Melania.
Exactly. I think it's really interesting. I'll just give the Italian view. So first of all, we have the NCBAs who sometimes address this. So they provide for special indemnities for the business travelers and so on. And there is case law that basically says if then we have to go and see each time how, let's say, strict the travel time is. So for example, if you're traveling on Sunday going back from the US, maybe you stayed over the weekend and whatever, and you are not strictly obligated to take that plane at that time. You organize it a bit, and during that time on the plane you can sleep, so it's not as if you need to be working during that time actively. Then case law says you are already indemnified for this, let's say, inconvenience by the additional money you are usually granted during a business trip. So basically, they don't consider it strictly working time. But if instead, you're traveling on a Thursday during working hours, it's not as if you lose your salary because you've been traveling on a Thursday during your working hours, because you would have, been otherwise. You're there on the plane for your employer who pays your salary, and you cannot do your active work because you're forced to be on that plane to come back to Italy. So it is a very complex issue. We need each time to look at the NCBA, and we need each time to understand how really force the employees to spend that time traveling for the employer, and what they can do during that time.
Thank you very much.
Yeah.
We just have a couple of minutes for a last question for you, Naomi. Are there any particular issue that you find common for business travelers?
Yeah, the phrase that I hear over and over again is, don't worry, it's fine. I can work for 6 months on my passport. And in particular, one of the biggest abusers of that route is Australian nationals, according to the statistics, and I'm an Australian national. But they do these things on a risk basis. And post-Brexit, obviously, there's a whole mental adjustment going on for the switch from being freedom of movement to not. And I've had conversations with potential au pairs, for example, who say exactly that. And my heart reaches out to them thinking, oh my God, you're illegally working in somebody's household. You're in such a vulnerable position. Please don't do that. So I just think that change in mindset is really important. It's not about being able to come in and do whatever you want on a visitor visa. You have to assess each trip on its legitimate, permissible activities or not, and ideally allow more time because of that process with the ETA and criminal convictions being a problem.
Thank you very much, Naomi. Unfortunately, we didn't have the time to take all of your questions, but panelists will reply to your question via email should you have any more of those. You can send a question via email to the email address that are mentioned in the slides. We have a variety of resources and insights on the cross-border employment rules on our website, as also Melania has shared, so don't forget to check them out. And for more information on our webinars, you can visit the webinar section on our website to find all the past recordings and download the slide decks. While you're there, take a listen to our podcast, Talking Work, in which we talk about the world of work. And finally, I would like to thank everyone for attending, and thank you to our panelists and moderator for their insights today. And so with that, the webinar will now be ending. Thank you very much and have a great rest of the day.
Thank you. Bye.
Thank you, everyone.
Bye.
Thank you. Bye.